Hello, everyone. I'm Richard Fink, a lawyer specializing in workers' comp. Today is the Injured Workers Legal Side podcast with Richard and Paul. Paul?
Hello, everyone. Now that was my failure before I've chastised you, Richard. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation and human rights law. If you want to reach either Richard or myself, you can do so through the links below.
Today we have on our podcast Pamela Hughes Ford, who is a legal assistant at my law office. And today's topic is the legal representation of injured workers in their disputes with the Workplace Safety and Insurance Board. We are going to talk about legal fees, how they're derived, how they're charged, what is charged, and representation availability for injured workers generally in having legal representation. Let me just give a brief summary of what we do at our law office. We mainly work on contingency, but we ask injured workers for a relatively small retainer, which we base on how much money the injured worker has available, how strong their case is, and how much difficulty the case is going to be. Interestingly, I was speaking to Mr. Allen, who's a lawyer, excuse me, who's a paralegal, who's a retired auto worker, so he has a full pension from his many years as an auto worker. And he told me he takes on the cases without any uh, fees paid up front. And most of his injured workers are extremely poor. And it's more of a hobby for him than it is a business. But for us, we have to be careful not to spend $5,000 worth of time on a case that's going nowhere with only a small retainer of a few $100s. So, Paul, how do you look at that?
Well, that's a good question because many would see, especially injured workers, that they're in a hell of a state, let's be honest. In that it's not only that they're fighting a legal battle, is they've literally, like the courts have said, lost their ability to earn a living. So you totally sympathize with that situation, but unfortunately, you have to balance things. You have to say, okay, well, the representative, you know, there, and I get an upfront fee, meaning, and that would cover your review of the file because these files, I've yet to see a file that's maybe 15 or 20 pages and takes me like half an hour to read. I would thank the gods if I ever got one like that. Like one file I just got from Manitoba, because I do Manitoba and Alberta as well. And the guy's not bugging me, and I get it. I do get it, and it's like something like in the neighborhood of uh 3 or 4 thousand pages, and I'm just like, yeah, this is typical. And what has to be done, and correct me if I'm wrong, Richard, what I do is, because it's beautiful, it's PDF now. I don't like old school paper anymore because and visualize an old guy like yourself, Richard, where you go through and highlight, make notes on the copy and use post-it notes and everything else. Now in a digital format of PDF, what I do is and I hate to say it, but I do give praise to the WSIB because they create sections. So they organize it a bit. And they have like correspondence section, medical forms, and things like that. So I then digitally bookmark in Adobe all the sections. Then I go through and bookmark all the documents. Once I've done that, then I start reviewing the file. And one of the biggest things I do is I go right to the forms section and look at the initial forms and identify the issues. And to do all that, it takes time. So yeah, I do agree with that. You can't expect people to work for free for an inordinate amount of time because it's not like I have yet to hear somebody say, an injured worker, especially including myself, say, I don't have a case. They all say that. And they have to understand that's their perspective on experiencing what they know in the file. They don't understand the comparison to what they know to the actual policies and the law and the practices, and you have to combine the two in order to say it does. And they're just reviewing it, and that's one hard lesson I learned through the whole process was there's right and wrong, and then unfortunately there's the law, and they don't always parallel or they don't always work together.
Well, the file I did this morning with the assistant lawyer in our firm, Josh Kirschenblatt, it was 2,500 pages of material, and I was just looking at the time he spent, and he spent 8 hours reviewing it and making notes. And he still has some more time to spend in doing an opinion to the client. And I think we charge the client $1,500 to review in part because the client has been in receipt of benefits up till now. So there's no real money going backwards to collect for our fees. And it's all a question of whether we can assist the injured worker with their entitlements going forward. So we charged 1,500, and if we put Mr. Kirschenblatt's time at $300 an hour, which is quite reasonable for a lawyer, you can see that we're about $900 to $1,000 when you throw an HST behind. And the case, many of the cases we get, and the reason injured workers should get a lawyer is this particular injured worker has missed 8 time limits for filing appeals on various issues, which I think Pam recently sent out letters to the WSIB and to the appeals tribunal saying we're appealing now, as in better late than never. But the point is that if the injured worker is just chasing a few dollars for physiotherapy, let's say they want 6 physiotherapy appointments paid at $100 each, don't bother with a lawyer. But if the case is going on for more than a few months, you need a lawyer because it's so bloody complicated. And time limits, getting the right medical reports, complying with WSIB requests. If you don't have somebody fighting on your side who's been there before, like a lawyer, paralegal, you're asking for trouble.
The other
Yeah.
thing that,
Oh,
sorry,
go
if I
ahead.
could
No,
interrupt,
go ahead. No, go
the
ahead.
other thing that I was going to say that I don't know if people take this into account, but with the time that not only you and Josh Kirschenblatt spend on the file, there's also, our office admin staff that's dealing with mail. There's also myself that's dealing with letters, like you said, the appeals letters that take time, all the phone calls that are behind the scenes. I don't know if people realize how much effort and time is actually put in on an individual file. Some of the files that I deal with when I'm doing implementations and letters, I could speak with these people plus speak with the WSIB more than once a week. I mean, I could be spending an hour or two a week on certain files when there's a lot going on at that time, whether it be like a return to work situation or implementation of an ARO decision or WSIAT decision. And I don't know if people actually realize how much time and effort it takes. And it's not just the lawyer, it's people that work under the lawyer or under the paralegal at whatever law firm it is. So
The
it's
support
good
staff.
for, yeah, it's good for people to be aware of that. Like I'm on the phone 90% of my day now that the work disruption's over. And that's
Right.
typical for my day, in addition to answering emails and letters and doing work that Richard and Josh are giving to me. So it does take a ton of time to work
Right.
on anybody's individual file.
See, with me, I'm just an individual, Pam. I don't have any, well, unless I count my dog. I mean, it's my assistant. And I mean, he'd probably sometimes be more coherent than me. But in all seriousness, I have to answer your question, Richard. Generally, I don't charge a fee to review a file. I'm sort of like Bruce Allen, I think his name was. But at the same time, where it complicates things with me is if the client goes to you, they'll probably get an immediate response and things like that. Whereas with me, it takes a lot longer and they have to understand, and I try and make them understand, but it usually doesn't work, that I have to balance immediately paid work with work that's going to take anywhere from 6 months to 2 years to pay or even longer sometimes. That's another huge factor is when you're dealing with contingency. I deal with it at Human Rights Tribunal, Landlord Tenant, and WSIB. And all three of them, your average time is between a minimum of, say, a year to as high as 10 years before you'll see anything. It's not greed or anything, it's survival. You can't survive in that time period of waiting for these decisions to come forward. So you have to literally take on additional work that pays you at the time and balance your time as best you can, which causes frustration with clients. And I get it. I totally understand the frustration. Then there's the other factor of what else was I going to say again? Was balancing clients like where they have a case, and I do bring up free services. I say, you do have these options. It's not that I'm saying, I don't want you to hire me. It's I want to be honest and genuine with them and saying these free services are available. And some of them can be very good. Unfortunately, thanks to government cuts over the last 30 to 40 years, they've been really drained, meaning they either can't get to you for, like when I was an injured worker, I was told when I first dealt with my injury, the OWA represented me right away, and it was no problem. It was before 98. Then when I went back to them to say, hey, they're denying my benefits again, they said, yeah, you'll have to wait about 2 years, 2 to 3 years. I was like, what? And then that wait time went up as high as 5. Now, the government and everybody's saying their wait times are down, but I don't know. I don't watch them. I'm not them. Um, the other problem is that it's incentive. It's not that I'm selling one or the other service. It's that it's difficult because unlike the OWA or the legal clinics, they'll deal with more, but they're specialized and limited in the areas. But the OWA specifically, they'll deal only with WSIB WSIAT, whereas with Richard, he'll do judicial review if needed, and if, I don't know. And Richard can talk about that. Whereas with me, I can deal with a human rights complaint application. So I can jump outside the WSIB if the employer and or the WSIB has acted contrary to the code. So that's an asset to the injured worker in that sense. Um, the other aspect is the wide range of law. Like I understand criminal law and things like that I do. So that brings something unique to the table. The other thing with contingencies is that contingencies, to be clear, by the way, Richard didn't explain it first because he's a lawyer like me, where we talk in jargon and it's like, oh yeah, by the way, contingencies is where myself or Richard will do it on a percentage of the end result. And like I say, that could be anywhere from a year to 10 years, depending on the delays. Now, the boards hopefully are starting to pick up speed because there's been a big, huge public backlash about all these delays. But that said, that's one of the problems. Now, I do again, getting back to that point of taking or charging a fee and then percentage, a combination of the two. It makes perfect sense because you're just covering the cost to review the file. And that
Oh, let
cost
me
can
ask
be
you a
expensive.
question.
Go
Let's say
ahead.
you need a report from an orthopedic specialist. Who pays? You or the client?
In that situation, that would be a disbursement, and according to contingency, it would be the client, right? But I mean, like, there's law firms. See, that's a gray area in a way because according to this, now lawyers and paralegals in Ontario, and me and Pamela were talking about that earlier, was that the Law Society created a rule that all lawyers and paralegals have to use the same formatted, structured agreement contract for doing percentage or contingency based agreements, and it's standardized. We also have to give you like a 12-page guide. It's good and it's bad. It's good because it gives you that moment of reflection to say, do I really want to do this? Right? It's not that Richard's a bad or I'm a bad person or anything. It gives you that moment of thing. I always encourage people take a day or two to think about it. I don't want you coming back a month later and go, oh no, I really regret this, or a year. It's also good because it's structured, but the problem is like Pamela was saying, and I agree with you, Pamela, 100%, is it's generalized. Like my retainers are generally generalized too, because I do small claims court, criminal court, and all that stuff. But when you're specializing, people who reading lengthy contracts do get confused and overwhelmed. I mean, it's taken me a long time to focus my all over the place brain to go, no, no, this is what this means. Like I would be very easily overwhelmed by these contracts. You know what I mean? And
Let me,
saying,
let me
wait
ask
a minute.
let me ask Pam a question, which is what is happening with the future entitlements? So let's say the worker gets $30,000 retroactive payment from the WSIB, but the WSIB is going to pay them for the next 4 years, let's say 20,000 a year until they hit 65. How are we dealing with this future payment in terms of charging people for that future payment they're going to receive?
So what we do is once we have a decision like that, we would do a letter explaining exactly what the retroactive, which is back pay, is. Then we would explain this is how much you're going to get forward. As per our contingency fee agreement, we charge 20% plus HST. So then we would tell them, okay, we would like within 30 days of the date of our account, the 20% plus HST based on the back pay because it's a lump sum payment. And then going forward, we would say, this is what we would like to pay. This is what we want you to pay us by the end of each month going forward for however many years it takes. That way, they feel confident that if something happens and the board changes their mind or cuts off their benefits, they haven't overpaid us. We also do explain to people that should they decide, because some people do, say, listen, I got a lump sum, I'll pay you all the money now. I will then send them a letter just to reconfirm if you're paying us on your future fees and should something change with your future fees where you're cut off or you have questions, you come back to us and we adjust our bill accordingly. So if something ever happens and those, they've overpaid us, then we deal with it right away. But we always give people that option of how do you want to proceed with this? And we do right now have quite a few clients that just at the end of each month, I have a chart that goes, did this person pay their installment? And if not, I send them follow-up phone call, an email, or a letter. Some of our clients give us post-dated checks for like a year at a time. So there's always ways to work around it. I'm not sure what anybody else is doing, but that's how we handle it because we don't expect people to be able to pay us for money that they don't have in their pocket yet unless they feel comfortable because of their situation.
I spoke to one lawyer who went to a judge to get his future fees approved. In other words, the client receives money into the future, and the lawyer wanted him to pay for his future entitlement. And the court actually stated the injured worker didn't have to pay. And the Law Society also did an investigation, but sort of made just a suggestion that he follow the format. So there is some area of the unknown in terms of the future fees. In motor vehicle cases, essentially always what happens is the future entitlement's paid in a lump sum. And uh, there's thousands of lawyers doing motor vehicle cases, but only dozens doing workers' comp cases.
Well, sorry, one of the reasons though, Richard, you have to keep in mind is with WSIB, people don't realize the money does not come to the representative. And that's what a huge problem is for us, right? Because in personal injury, money goes to the representative. They take their cut for their fees, then they give the money to the client. With WSIB, it goes to the injured worker. We then have to send our bill, and then we have to worry about how we're getting paid. And if we don't, which we've had this discussion, Paul, before, then it's like, how do you get your money? You then have to go to small claims court, see what you can do, what the situation is in order to get your fees that you're owed.
See, that's called in a legal term, that's called third party assignment. And all my retainer agreements when I deal with human rights tribunal, LTB, all of them, um, when the case is settled, the other side, usually how it works is the other side's client will pay their lawyer and then they send me the money. Then I take my fees out and then I pay my client. And that protects everyone. The problem with the WSIB, and I don't know why, but they have a rule in their law, they have a section in the law and their policy that says clearly that any agreements for representation will not be applied, meaning the WSIB will not assign benefits to a representative. And it bothers me because many will say, yeah, that's right. But then what's happening then is that you're limiting individuals, paralegals, lawyers wanting to represent injured workers, wanting to get into that field of work, reducing the ability to find a representative for injured workers to fight their justified. You may have an amazing case, but then you don't have anybody to represent you because you can't afford to pay people up front. And that's one of the issues I've battled with for years now and saying, it's unfortunately it's a trust factor. And people will go, I promise I'll pay. And I'm laughing because I have cases, in fact, I have two right now that are going to small claims court, and they're small claims court issues where they were both businesses and they're both very prosperous and said, no, no, I'll pay it, but don't worry, don't worry. And I'm like, okay. And I make that mistake. And then they just go, no, I'm not paying you not because they have a legitimate reason, they just don't want to pay. And that becomes a problem when the law supports that. It's like, no, you're disrupting a delicate balance. Now,
My favorite story is a lawyer who's even more senior than me. About 10 years ago, the client's address would be the address of his law firm. So when the check came for the retroactive payment, it would come to his law firm, and he would tell the client, if you want your money, you have to come with me to the bank, cash the check with the both of us there, and then take the money from that check and pay my fee. Anyways, the Law Society not the Law Society, the WSIB put an end to that because they refused to use his address anymore as the mailing address for the client.
but I mean, I get
That's how he figured it out for quite a while.
I get if there's paralegals and lawyers that are unprofessional, unethical, and screwing the injured worker and clients. I get that. What angers me is that the WSIB is taking, in effect, and the legislature, they're taking the law into their own hands in a way to deal and to discipline lawyers and paralegals is the Law Society's job. And that's where it should be left. They shouldn't be doing what they're doing now and saying, we're not doing that. They're treating it like welfare because only welfare cannot be transferred. And I'm like, it is not welfare. But the other issue that I wanted to talk about is that, well, a client, and I've proposed this to many of my clients saying, look, if you're really pissed off, sorry, but that's the only word, about your fees paying me because they cheated you and they acted, what was the word, Richard? In bad faith with the way they administered your file, then you could use that case. What was it called again? Castrillo v. WSIB, where you proved that you can sue them for your legal fees. Because the board and tribunal will say, unlike the courts, and the only one that I know of so far right now is Landlord Tenant Board and Law Society that will award court costs as your legal fees. So you can in that case. So what you could do, what the client could do is say, okay, Paul or Richard, I have to pay you, say, $10,000 or $5,000 in legal fees. I want you to sue the board in small claims court for my fees. Now, you have to meet that bar, that threshold like Castrillo, and I believe you'd have a really good case. And the best part is that it wouldn't be so easily dismissed as in the higher court because small claims court, it's almost impossible to get a claim dismissed. I'm dealing with one right now where it's statute barred and the judge is like, yeah, no, I don't think so. And I'm like, but so there is what I'm trying to say. I know there is what I'm saying is there is a good alternative solution to this between the injured workers and reps. You know what I mean? Where both are happy because really what's happening is I'm having to hire you, Richard, or you, Pamela, to deal with this problem with the board that they're not treating me fairly. Why should I have to pay my legal fees? And I agree 100%. So then don't sit there and gripe about it. Tell your representative, hey, look, my fees are, let's go to small claims court. And if it's like 40 or, well, as of October 1st, if it's say 52,000 because small claims court is going to 50,000, waive your monies over the 50 to keep it in small claims court, right? And see if you can win. You know,
That's a good idea. And I hadn't thought about small claims court because our problem with going to divisional court is the amount of time is like $70,000 worth of time.
well,
And I've been telling clients, you want us to go sue the WSIB for misfeasance, we need 50,000 to start. So small claims court, maybe with 5,000, we could trundle over there. Let me just make one final point. I go through the appeals tribunal reported decisions where they're summarized every couple months. And when I look at the decisions, only about 20% of them are as the representative from a clinic or from the worker advisor. So 80% of the representation is the private bar and paralegals. And the other thing is the appeals tribunal is overturning about 3 or 4,000 decisions per year of the ARO. And there's only about 20,000 cases that get to the ARO per year. So the ARO's correction rate uh, is at least 15%, which is a very large failure rate. So what we're looking at in terms of legal representation is just one part of a real conundrum in terms of workers' comp.
add to your point there, Richard, I'm doing some side research on the WYSIAD, specifically in the area of reconsideration. So you went to the WYSIAD, and in your opinion, they made a bad decision, meaning they either error of law, error of fact, whatever. And I wanted to know, were they self-represented? Who were they represented by? Paralegal, lawyer, union, or legal aid clinic? And I did 2024, 2023, and 2022. And off the top of my head, I believe there was only one successful reconsideration by legal aid clinic and one by union. The rest were generally lawyers and paralegals, and I would say they were equal or more paralegals because that's the area they do usually, but lawyers were just as successful, I think. So it's an interesting point about reconsiderations, and there was only one self-represented successful. Like,
All right, well, we'll end it there and thank our audience for joining us again and see everybody next week.
thank you everybody
Thanks,
for
guys. Take care.